Hello, everybody, and welcome back to Raid Digital. Thank you so much for joining us. It's been a fantastic day so far. 5 panels across a whole range of fascinating topics so far in this brilliant online platform. We're very much looking forward also to seeing you face-to-face in Brussels. Just to remind you that we'll be in Brussels on the 26th of September at the Stanhope Hotel with our trademark mix of policymakers, regulators, and technology experts from all over the world to talk about technology regulation there. And now we're moving on to a panel about personalization and fairness in the modern data ecosystem. Technology platforms are brilliant in sort of helping us to in understanding sort of what our sort of desires are, I suppose, and our interests, and which has all sorts of benefits for the user. It can also cause some challenges when that is extrapolated to larger groups. Potentially there are ethical issues that can arise that if not navigated correctly, which is of course what the platform providers and the regulators are working together to achieve. So what we're talking about here is what does personalization mean to individual users? What are the benefits and challenges of personalization from the user's perspective, for example? How does the concept of fairness manifest itself in the personalized digital experience? And how does the GDPR program help to ensure fairness? And what's the link between personalized services and user agency? So here to these questions and more, we have a fantastic panel of experts from various different sort of stakeholder angles on this topic. We have Cian O'Brien, who's the Deputy Commissioner for Data Protection Commission of Ireland, where many technology companies are headquartered, as I'm sure you're aware. Cecilia Álvarez, who's the Director of Privacy Policy Engagement at Meta. She's very expert in these matters, and you may recognise her. She's spoken at RAID before. Welcome back, Cecilia. We have Seng Ah Lee, who is Senior Manager of Risk Analytics and AI and Data Science at Deloitte. Welcome to RAID, Michelle. And we also have Giovanni De Gregorio, who's the PLMJ Chair in Law and Technology at the Católica Global School of Law. So a very warm welcome to you all, and very warm welcome to our audience as well for joining us again and for this fascinating panel. So Cecilia, perhaps I could turn to you to give, so we're here to talk about personalization. But what do we mean by personalization? What does personalization mean to individual users from your perspective? What would you say are the benefits and the challenges of personalization from the perspective of the user?
Thank you very much, Ben, and thank you very much for the organizers of this conference. I am very honored to be again participating, and in particular with such a wonderful panelist. So let me address the question. Before joining Meta, I've been extensively working in the health sector, and way before, regarding the financial sector, but also the entertainment, retail. And the things that I have been saying in all of these sectors is that personalization has been something important, either because the organizations were already experimenting with it or they were aspiring to go there. And why this was so important for organizations of such different sectors is because there is a positive effect with respect to either that you have a therapy that could be more effective when it is personalized, or because when you would think about maybe other sectors different from a medicine or a therapy, that individuals feel that the organization is caring about you, is taking time and efforts in order to identify what matters to you in particular. And this has been something that I have seen in all of these sectors. And it's not only a question of feeling, but it's something actually that can be measured and has been measured. And if I take some reports, and there are many of them, regarding the effects of personalization. I can take one, for example, of the Harvard Business Review that was concluding that 38% increase in productive revenue was coming when customers were receiving transparent ads based on their activity on a site. Another report that has been issued by Salesforce was saying that 70% of consumers are saying that the company's understanding of their personal needs influences their loyalty. Another one, this case from Accenture, that was referring to 91% of consumers that were saying they are more likely to shop with brands that provide offers and recommendations that are relevant to them. And this is something that is consistent with the experience that I have then at Meta, and in particular, with respect to the use of Facebook apps and technologies. There was a specific report that was issued in 2020 of the Copenhagen Economics in order to survey businesses across 15 European Union markets regarding the use of, in this case, Facebook apps and technologies. And the result of this report, among others, was saying that these have been helping them to generate sales corresponding to an estimated of euro 2008 billion in economic activity in the year that was under analysis, and that this was translated into an estimated 3 million jobs. So the idea is not necessarily that we discuss only about personalization, but it seems that there is a certain understanding that personalization per se has benefits for individuals. In the case of Meta, there are legitimate interests of individuals to be able to exercise fundamental rights such as the freedom of expression or freedom of reunion for free, and for free for them, because it's not free, it is paid by the advertisers, but with respect to the access of the exercise of these rights and to receive relevant information, and for the brands to be able to access to an audience without accessing personal data in a manner that is particularly cost efficient, as opposed to the circumstance that we had earlier, in which we have very limited ways for organizations to be able to advertise their products and services through the TV at the time, or through the radio, or through the newspapers, in a very different world to the one that we know each other. So the important, I think, discussion that we are going to have today is probably not necessarily to focus on whether personalization is a binary thing that says bad or good, but rather that to acknowledge how these personalization models actually can be done in a fair manner, because it is not personalized ways of doing things can be done in very different manners, and this is something that matters. When we have the DSA discussions, we have a discussion as well regarding the ban of personalized ads in particular, and it was resolved not to do this because of these benefits that we have for the society, for the individuals, and for organizations. However, the DSA was focusing on looking at perceived or actual harms regarding, in particular, the use of sensitive categories of data as targeting options, or how we were addressing this when the audience was young people, or in particular the topic of the political ads that has been discussed differently and in a separate file. So I think, leave it here, but I think that it goes nicely to what we are going to discuss regarding what matters with respect to how we do this personalized experience, either through the ads or otherwise, and how we go into this fairness concept, maybe by addressing transparency, addressing guardrails, addressing individuals' agency, but I think we will have time to go through these concepts afterwards. Thank you.
Thank you, Cecilia. Really interesting to hear there. Sort of just dipping our toes into the details of the DSA there, and what how that's shaping up in relation to sort of these issues. Another major piece of legislation already passed and already well implemented, and a global standard, is GDPR, which doesn't really talk about personalization, but it does talk about fairness. And so Cian, perhaps you could give us an overview about how you would go about interpreting the fairness principle, which is in, I gather, is in Article 5.1a of GDPR.
That's right. Thank you, Ben, and thank you indeed to RAID for organising this topic, a panel on this important topic. As you mentioned, the fairness principle in the GDPR is provided for in Article 5.1a. And when you look at Article 5.1a, I think something that stands out is that fairness is provided for alongside the principles of lawfulness and the principles of transparency as well in Article 5.1a. However, the principle of fairness is somewhat of an outlier in that group, in that lawfulness and transparency are further developed in the text of the GDPR However, fairness isn't. So when we talk about lawfulness under Article 51A, we know that, for example, Article 6 of the GDPR sets out an exhaustive list of lawful bases for processing personal data. Similarly, when we talk about transparency under Article 51A, we know that Articles 12 to 14 of the GDPR set out what information must be provided to data subjects and how that information must be provided to data subjects. But in respect of the fairness principle, there's no other provision of the GDPR that defines that principle, and there's no other provision of the GDPR that develops the principle. And this makes it an outlier not only in the context of 51A, but also in the context of the principles generally in Article 5 of the GDPR. So, for example, Article 51C sets out data minimization, and we know that the right to erasure develops that principle in Article 17 of the GDPR. Similarly, 51D sets out the principle of accuracy, and we know that the right to rectification in Article 16 of the GDPR further develops that accuracy principle. Similarly, 51F sets out the principle of integrity and confidentiality, and again, Article 32 of the GDPR further develops that principle. So because the fairness principle isn't further developed within the text of the GDPR like the other principles are, I think perhaps in some ways it's the best example of how the GDPR is a principles-based piece of legislation and how that principles-based approach works in practice. So the GDPR doesn't define or prescribe exactly how existing technologies might infringe the fairness principle. And in some ways, it makes the GDPR, that's one of the GDPR's great strengths, in that it allows the GDPR to respond to technologies that weren't foreseen when the GDPR came into effect, or maybe even that aren't foreseen at this point of time either. However, that element of it as a principles-based piece of legislation also makes interpreting Article 5.1a and the principle of fairness, it creates a significant interpretive challenge in respect of that interpretation. And what we know from the first 5 years of GDPR enforcement is that that interpretive challenge falls on regulators in the first instance, who have to interpret and apply Article 5.1a in the absence of any Court of Justice judgments that comprehensively set out the scope of the fairness principle. So I think when we are discussing the fairness principle, we have to acknowledge that it's designed to be flexible enough to respond to new technologies. So I certainly won't attempt to exhaustively define the principle today. However, I do think it's helpful to focus on how personalization can cause unfairness. And the main issue that I'd highlight in respect of that is that unexpected personalization is likely to cause unfairness under Article 5.1a of the GDPR. So far, we have two separate sets of guidelines from the European Data Protection Board that have sought to define the fairness principle in Article 5.1a. And while neither set of guidelines, one being the 6.1b guidelines and the other being the Article 25 guidelines, and neither set seeks to exhaustively define the principle, but it's noteworthy that both sets set out that processing that is not expected by the data subject can result in unfair processing. And in this respect, it's really no surprise that transparency of processing is so closely related to the fairness principle. As I mentioned earlier, they are provided for in the same provision of the GDPR in Article 5.1a. And I suppose there are a range of different issues that could result in processing not being expected, and therefore result in an infringement of the fairness principle. For example, the use of dark patterns could result in unexpected processing, the use of default settings that automatically enable certain types of personalization. Each of these issues and many others could result in unexpected processing, which in turn can result in unfair processing. However, it has to be acknowledged that even where processing is expected, this can nonetheless lead to an infringement of the fairness principle if that processing results in discrimination or bias, or even if it results in unjustifiable adverse consequences for data subjects. So I suppose in conclusion, in terms of the scope of the fairness principle, it's a remarkably broad principle. We've had binding decisions from the European Data Protection Board that set out how Article 5.1a is an overarching principle in the GDPR. which means that essentially it has a very broad scope. It may well, in many instances, be accompanied by other infringements of specific provisions, but it's also overarching in the sense that it covers wrongdoing that's not covered in other elements of the GDPR. So I think that certainly where infringements of these principles are found to be occurring, the issue of corrective powers is a very significant issue indeed.
Thank you very much, Cian. And it's a good example of how GDPR is sort of future-proofed, as you say. It's able to be interpreted in the context of new and evolving technologies. So moving sort of taking a higher angle still, Giovanni, perhaps you might be able to give a view of how you would interpret the concept of fairness as a principle within the framework of processing users' data.
Yeah, I mean, thank you so much. This is a very big question, as you have already understood, I mean, from what we said so far. Actually, I mean, the first starting point is that fairness is a principle. So whenever we address or we deal with principles, we are dealing with something that is not defined by definition indeed, because we are dealing with something that is general and the scope needs some implementation that, of course, gives shape to what we mean as fair. And this also works for when it comes to data processing and users' data processing in this case. And so the question, in a certain sense, when we interpret the notion of fairness, is not only to interpret what fairness means in users' data processing, but also who are the actors involved in interpreting fairness. Because at the end, these actors will be at the end responsible. I think just think about how the GDPR is designed. These actors will be the ones responsible to say what fairness is, and sometimes we are inclined to think that fairness is something for data protection authorities, it's something that should be scrutinized by courts for sure. But when we look at the GDPR, the notion of fairness is very much in the hands also of the principle also of accountability, and so the data controller. And so I think that when the interpretation of fairness is not something that is just related on what we mean with fairness, but also with whom. So the question is that who is actually responsible to shape this principle? And responsible, I do not mean liable, of course, but I mean accountable. Who is the actor that actually is interpreting this principle? And that is actually, and then how does it, and what is actually the standard to interpret this principle, then opens the discussion about the question of risk-based regulation, for example, in the GDPR, but also when we deal, for example, with public administration that actually also provides platform where they're processing data as well, it's another challenge. So I think that the question of fairness as a principle is very hard to answer. This is actually how we should interpret fairness, particularly when this notion is not interpreted as a court, as you expect, for example, sometimes, but is usually and very often implemented in the field of data protection by data controllers. And when we talk about user personalization, these data controllers are very often, of course, also private actors. I think that this is something that sometimes escapes the logic because we tend to say that fairness is a very broad principle. Yes, it is, but it's broad exactly because it is not supposed to have a certain content, because the content of fairness is shaped by the contextual framework in which we talk about fairness. That, of course, it cannot be unique. It changes when we address a case of a startup, or we change a case of an online platform, a big one. Or it changes again when we move, for example, to the public sector. So I really believe that, and this is actually the message at least that I think it's important to understand, it's more about understanding the context, also looking at Article 24 of the GDPR, who is the data controller, where it operates, who is, the size of data control, the nature and the context really makes the difference how we define fairness in the user's data processing.
Thank you very much, Giovanni. Yes, there's an awful lot of scope for interpretation, as you say. Back to something that the Cian said a moment ago. You mentioned that that there is a risk that the fairness principle, if back to personalization, actually, which if it infringes the fairness principle, it can result in bias. Now, onto this question of moving on to the subject of bias, perhaps Michelle, you might be able to give us a view from your work about some of the ways that unintended, unfair biases can get introduced through AI, for example, through the AI lifecycle.
Yeah, sure. So I completely agree with what was said with Giovanni, that fairness is a complicated and inherently subjective and context-dependent concept. One of my academic papers actually looks at the disparity between how computer scientists, ethical philosophers, and economists define fairness. So, for example, a lot of the definitions in the computer science field assume a clear distinction between what we call the legitimate input features like income, etc., and what are illegitimate or irrelevant features like race. But very often in especially large data sets, the proxies of the prediction are closely intertwined with proxies of personal characteristics. And there's a lot of discussion around the context dependency of what is a proxy and what is a legitimate feature in non-discrimination law. And this is discussed in Sandra Wachter's Why Fairness Cannot Be Automated, which is a well-known paper. And from an AI developer or algorithm developer standpoint, like myself, we're concerned about the unintended harm, introducing unfair, unintended biases into our data and into the algorithm. So these biases can be introduced throughout the life cycle, and that can be through the data collection mechanism, like only sampling or collecting data from specific subgroups, or because of the nature of like the marketing algorithm that only collects data from certain kinds of individuals, through to the design decisions and feature engineering phase and addition of subjectivity of the developer in that process, or through the feedback loop as we learn from previous examples. And when we assess an algorithm for fairness issues, we have to be cognizant of all these potential pitfalls. And sometimes these undesirable biases or these fairness considerations, I guess, like exist in our data set, especially when we have such a large data sets. And when we train algorithms on much more data than humans can digest, they're identifying patterns in our predictions in unexpected ways. And these patterns can sometimes be associated with not just what personalization is trying to achieve, but also with who we are, including our race and gender. And there's a risk that the algorithm can identify patterns that exist because of past discriminatory or exclusionary practices, and training them on historical data can replicate the harmful bias. And the concern is that on a societal level, that can worsen inequalities at an unprecedented scale as these kinds of algorithms become more and more prevalent across different high impact domain areas.
Thank you, Michelle. I think that's something that we're all becoming sort of acutely aware of now as generative AI sort of enters the mainstream, and we're all becoming a bit more aware of how these systems work and where they're getting the information from, and the risk of just sort of feedback loops, as you say, just amplifying sort of assumptions that are already in the public domain. So thank you very much for that perspective. So staying on the back to fairness and moving away from unfairness. So Cecilia, for you, how does the concept of fairness manifest itself in the personalized digital experience? How can a digital experience be fair? How can it be free of bias? How can it be safe? How can it ensure dignity?
Thank you very much, Ben. I think I will build on all the comments that have been already made by my co-panelists, because I think they give a lot of clues, at least with respect to certain issues that I will be able to share with you regarding, in particular, Meta's practices. But I will start first on where I ended in my previous intervention, in the sense that it's very important to understand that personalization may vary, even if we focus now on ad personalization, from organization to organization. As Giovanni was saying, it's very important to understand how each organization is actually adopting measures with respect to how this personalization is made in order to make the relevant assessment. So that is not the same thing to think about real-time bidding systems, and maybe among each of them there could be differences. I do not know them that much in the sense of making this kind of assessment, but definitely is very different to what happens in Meta's personalized ad system that is not based on real-time bidding, but is something that is based differently. And I would like in particular to mention two kind of measures that goes into the direction of what has been made before regarding the importance of transparency in order not to go into this area of unexpected personalization, the use also of how important it is to have a certain kind of default settings that are going to have an impact also in users' agency, and also in order to go into this discrimination or bias or other kind of unintended harms that should be taken also into account, or at least that has been part of a journey, of a privacy journey of Meta system, that the one that we have right now is probably inheriting from the learnings of a very long journey in this respect. So if I focus on the guardrails, we start, for example, regarding transparency in very different areas. There is the area of explaining in the terms of use very clearly what is the contract that Meta is offering with respect to this personalized experience, also with respect to personalized ads. But this transparency is not only focused on how clear the company in explaining this personalized experience as part of the contract, but also regarding other kind of measures such as why I'm seeing this, which is another kind of contextual transparency that you can see in each and every post, including each and every ad, that tries to provide an explanation of how the algorithm works, not by providing you the mathematical operations that the algorithm used in order to deliver ads, but for you as an user to better understand which have been the signals that have been provided to the system, either through your activities or the activities or the friends or those who belong to your social graph, that are going to have a particular weight in why you are seeing this particular ad. For instance, in order to avoid, as I mentioned before, this unexpected personalization. Other measures that are not linked in this case to transparency vis-a-vis the individuals are with respect to a measure that Meta took consciously of not providing personal data to the advertisers. So the way in which the system works is by enabling advertisers or brands to choose an audience in the sense of identifying demographics and interest in order to address the ads. So, for example, women between 35 years old and 55 who live in France, unlike football, let's say. This is not an access, let's say, to the name of Cecilia, if I were, let's say, to be integrated into this criteria that I mentioned before, but to a way to ensure that the advertiser is able to access to reach those persons who could be interested or more interested than others with respect to the offer of these advertisers, but not by accessing personal data. There are other measures that are taken with respect to the application of community standards and advertising policies, which are two very different sets of policies that are enforced through AI and also through human review, and also by addressing user reports regarding kind of contents, and in particular ads that could be harmful in the sense of ads that could be breaching the laws, or could be scams, or could be porn, or could be discriminatory or inflammatory, or could even generate negative self-perception of yourself with respect to promoting weight loss. So there is a myriad, let's say, of very serious behaviors that are banned, let's say, from the platform, that are the subject matter of the community standards, and another set of principles that are these advertising principles, in order to avoid that the ads are actually going into the categories that I mentioned before, that are really addressing perceived or actual harms that could be used by bad actors through the advertising system. There is also a conscious decision in order not to enable advertisers to have as targeting option what is called sensitive issues, or issues that are very close to causes or organization or public figures that relate to health or race or political affiliation or religion or sexual orientation, in addition to the fact that the sensitive categories of data now, in the sense of the GDPR terms, that you may, as a user, have decided to include with your consent in your profile is actually something that has never been used for personalized ads. There are other kind of measures. These are measures that belong, let's say, to decisions that the organization, is this accountability model that Giovanni was mentioning, have been adopted. But on the side, let's say, of providing users agency, there have been also other kind of tools that have been put into account, in implementation, or other kind of default also settings that were mentioned also before. For example, third-party data, that is the information regarding your activity outside of the platform, is something that requires, in order to inform personalized ads, is something that requires in the European Union a consent through an opt-in. So by default, these are not kind of data that will be maybe more unexpected for users to be forming part of information that will be informing the algorithm in order to determine whether something could be relevant in particular for you or more relevant for you than for others. I already mentioned the why I'm saying this, which is this contextual transparency tool. But within this transparency tool, there are also controls with respect to ad preferences in order, for example, if the algorithm has came to the conclusion that I like football and it is actually not the case, or maybe it is the case, but this is not the place in which I would like to receive ads on football, I can actually remove this ad preference regarding football through the control that is incorporated in this why I'm seeing this, in order that the user may do something with the information that he or she receives. There are many other measures that have been taken on the side as well of the user's agency, but I will leave it here. But it's just to give a flavor of conscious decisions that have been taken on the side of guardrails in order to avoid ads off that could be harmful, but also leaving the users first to better understanding how this personalized experience works, and have also a say in the degree of personalization that they may receive in the platform, in order that they feel that they are receiving something that is fitting with the expectations that they have.
Thank you very much, Cecilia. Yes, it brings so many issues, but I'm going to stick to the script for now and move on to a question for Giovanni about fairness. And Giovanni, what would you say are the consequences of mixing the concept of fairness and accountability? You touched on this a bit earlier on, but how are sort of fairness and accountability linked in your mind?
Yeah, th thanks again. I mean, I think that the things that also Cecilia underlined raised this point about also understanding what happens when we have like some like general principles, like we know that we have in Article 5, and fairness is one of that, like with legality or transparency. And then at the end of the same list of principles, we have the idea of accountability that shows a lot, I mean, the role of data controllers in this space. So now here we're not talking about how the system of data protection should look like in a certain sense. We are not proposing here. We're talking about how it is and also what are the consequences of the actual system that we have. So, I mean, when actually we have a principle like fairness that, as I mentioned before, like is interpreted by the data controller and shapes, of course, the accountability also of the data controller, it is clear that also the nature of the data controller inevitably shapes not only the principle of fairness, but also all the steps that the data controller will implement in order to ensure the principle of fairness. And this, of course, makes all the difference, of course, if you are like a business actor, if you are an NGO, if you are a public administration, and particularly in any case, what is interesting is that it's about the implications of putting together accountability and fairness, and this goes very much towards the direction of a risk-based approach. And there are different parts of the GDPR that also suggest how important the assessment of risk is, not only, for instance, when you look at the data protection impact assessment, but also other cases where you can see that the GDPR leaves the data controller to make decisions. And of course, these decisions are very often dependent on the degree of risk for usually the fundamental rights of users, but generally speaking for the data subjects. And so this assessment, where actually the most important parameter are the users, makes all the difference when we talk about fairness and personalization. And this is why it's very, very important every time to understand also the context in which we are talking about this accountability and how it is possible to ensure fairness. Because a risk-based approach very much shaped not only ex ante but also ex post the approach is for processing personal data of users, but generally speaking, data subject as well. And this is also connected to Article 25 of the GDPR with the principle of privacy by design, and particularly privacy by default. So the putting together fairness and accountability leads us to talk about what is the scope of regulation, not only when we look at data controllers, but also more generally speaking, also in European policy when we talk about risk-based regulation.
Thank you. Thank you very, very much, Giovanni. We've had a question come through on the audience from the audience. So thank you for this. Whoever's asked this question, it's anonymous. They're protecting their data. The question is: can generative AI, which is the order of the day, can generative AI be used to monitor or moderate harmful content in real time? I'm not a technical expert on this. Who might like to give a view on whether generative or any other form of AI, for that matter, might be able to what role can that play in harmful content and how that might contribute to this debate on personalization and fairness? Perhaps Michelle, I don't know if this is something you would have a view on.
Yeah. Well, I can give it a start. So there have been a lot of articles on actually the presence of unintended biases and unfair biases in generative AI, because of how it's been trained on human language. So, for example, there have been examples where the generative AI model assumes that a nurse is a woman and a doctor is a man, and there are a lot of gendered language, as well as kind of racially biased language that can kind of reveal themselves through generative AI. So one of the key considerations in ensuring the proper control mechanisms and monitoring in place for releasing generative AI is actually identifying the potential biases in generative AI itself. Whether it can be used to detect potential biases, I think that would be quite challenging, just given that it in itself is also biased.
A very good question. So that's back to the point about feedback loops earlier on, which is one of the key challenges here. So from the data protection point of view, Cian, how might default settings be calibrated to help to avoid some of these issues? There's been some fairly high-profile cases recently that perhaps you might be able to refer to as well.
Absolutely, Ben. Thanks for that. I mean, so default settings for personalization are really crucial issues that controllers have to consider in terms of GDPR compliance. As Cecilia already mentioned, setting certain settings to enable personalization by default can result in that personalization not being within the reasonable expectations of data subjects, and therefore can result in a lack of fairness, an infringement of the fairness principle. But even going beyond the fairness principle, default settings that set personalization to enable by default can risk infringing the principle of data minimization and also data protection by default. So it's really crucial when controllers are considering whether to enable certain personalization by default that they carefully consider whether the processing of personal data that will be enabled is limited to what is strictly necessary for the purposes being pursued. So I think that controllers need to be very careful about default settings, especially if the default settings enable extensive processing of personal data. And this is an area that the Data Protection Commission of Ireland has been quite active in respect of default settings. We have 2 inquiries that concern default settings on children's social media accounts that automatically set those accounts to be public by default, meaning that anybody could view the social media content created by those children. One of those inquiries concerns Instagram and the other one concerns TikTok. And in the case of the Instagram decision, it found that the processing in question by making children's accounts public by default was not limited to what was necessary for the purposes of processing. And the DPC found infringements of the data minimization principle and also data protection by default. In respect of the TikTok inquiry, that's an inquiry that's actually still ongoing. It's at a very far advanced stage, and the DPC has submitted a draft decision to the other concerned supervisory authorities under provisions of Article 60 of the GDPR. So what I'd say in respect of default settings is that it's really crucial that controllers carefully consider what their purposes are in respect of the processing, and that they then carefully consider whether those purposes can be achieved effectively without the default settings being set to enable personalization by default. So it really is a case-by-case analysis, but one that must really be documented. And as Giovanni mentioned, it's really important that the accountability principle is complied with as well. So that's really crucial. Perhaps just to highlight another strand to that, I've mentioned the fairness principle and the data minimization principle and data protection by default. But really, by enabling personalization by default, in some cases, you can also risk invalidating a lawful basis, depending on what the lawful basis is. We know that for consent to be valid in the GDPR, it must be unambiguous. And with the Planet 49 judgment, we know that pre-ticked boxes do not provide unambiguous consent. Similarly, if you're relying on legitimate interests under Article 61F of the GDPR, really crucial to that legitimate interest balancing is the reasonable expectations of data subjects. So you can see how an issue that might really concern fairness at the core of it also kind of strands that lead into the lawfulness of the processing, whether data minimization is complied with, whether data protection by default is complied with. So it certainly really is an overarching element of GDPR compliance.
That's great. Thank you very, very much, Cian, for that overview there. So we talked earlier on about one of the possible sort of unfair mechanisms that can happen and of course should not happen is what's referred to as dark patterns, where users aren't really clear on what they're consenting to, and there can be sort of deliberate sort of avoidance of clarity with regard to consent. So this is obviously something which needs to be avoided. Cecilia, what's your view of the issue of dark patterns in user interfaces, and what responsibilities would you say that platform providers like Meta have in stopping this from happening? When you've talked a bit about yeah, go on.
Thank you, Ben. I just wanted to make also mention, since it has been mentioned, the Instagram decision in particular, in order to illustrate some of the points that were made before. So irrespective of whether the fact that there is an appeal on this decision, I really want also to mention regarding measures also that the organization took before actually the decision and afterwards as well regarding children. I mentioned before regarding the DSA discussion that there was a focus on specific unintended harms that were perceived or actual regarding sensitive categories of data, regarding young people, and regarding this has been addressed. And the company has actually made a certain number of changes for now a certain number of years. One of them is with respect to the accounts that are open in Instagram, that they are now defaulted in private, which is also something that I think is important regarding these default settings. And another measure that I think is relevant also to note is that the organization took the decision not to deliver personalized ads to young people that is based on the interest that the algorithm may build on them. There are many others, but I just want to point this out because this is something that is also relevant when we think about the guardrails that I mentioned before and the user agency as well. But let me now address, I think, the question that you have mentioned regarding the dark patterns. Before I am able, let's say, to share a specific work that the company has been doing in this particular field of dark patterns, I would like to make some introductory remarks on the thing. One is that there has been some guidelines addressing in the privacy sphere regarding dark patterns that seem to be focused only on social media, which is actually, I think, not fair to take one topic that has been discussed today extensively, in the sense that the dark patterns are not particular of social media. They are particular, let's say, to how organizations, public or private, are actually trying to organize their systems in order to get something in particular regarding the users. Some of the practices that are described in these guidelines are actually not particular at all of the online social media, but can be seen in many other places. The second thing that I think is important in this dark patterns scenario is how important it is to have the conclusions or the measures that we are going to take that are evidence-based. It is not a question of whether I think or not that something could be qualified as a dark pattern. Is that there should be a research that is backing my, as the case may be, my feeling or my thinking. It's not a question of how is thought by a single person or a group of persons, is whether there is evidence that bases the conclusions that we have. A thing in particular that strikes me sometimes is that when we speak about dark patterns, it seems that it encompasses everything, also poor design or poor language. Unfortunately, sometimes human beings are not necessarily those that do the best thing in terms of design and language. This does not encompass necessarily a dark pattern, even though there could be dark patterns as well in this area, in the area of the design or in the area of the language. But I think we should not be ending up that anything that seems to be poor ends up to be qualified as a dark pattern, as if it was really an intention to obtain a bad result, let's say, by using this. And the other thing that I think is relevant as well is that dark patterns in the area of privacy are specific kind of dark patterns that are not necessarily the same of dark patterns that could be related to safety or could be related to well-being. Each of these disciplines may have a say in this area, but they are sometimes it is conflated together. And I think that for the sake actually of having better conclusions and then measures that are addressing these conclusions, we need to be also very careful in how we address this. And now I would like to share with you what the organization has been doing in this respect. This started in particular with a pilot that we have last year in our labs of transparency, trust, and control platform regarding the research and we conducted on topics that related to users' privacy concerns, how to design effective privacy settings, and how tech companies can change their product development processes to better support users' privacy and other kind of topics. And I would like maybe to highlight two kind of areas in which this pilot was focusing on. One was with respect to how to make privacy settings easier to find, user maybe better names and organization of the same. And the research team identified two important strategies that help make privacy settings easier to find. One, that to present the privacy settings in shortlists that are grouped based on users' mental models for privacy topics. And the second thing is that use descriptive names for privacy settings that avoid the generic word privacy was also helpful. The other area of discussion was to follow the consumer journey in becoming privacy conscious. And there has been in particular a privacy researcher who interviewed consumers who had recently attempted to make conscious changes to their messaging behavior in response to a perceived privacy threat in order to better understand how consumers respond to privacy threatening situations. And there has been a specific report issued by this researcher, external researcher, in which we have a framework with a new approach to measure privacy concerns. Focusing more on the dark patterns concern, we have been doing a research with many different kind of divisions intervening in order to have a dark pattern taxonomy regarding the privacy dark patterns, focusing on 6 areas. One, the interface interference, for example, a prompt with prominent allow button and a grayed out skip option that could be more difficult to find. Other one that was hard, let's say, to experience to make more difficult for users to revoke or to adjust a data permission. For example, an overly long process with additional friction for people to change the visibility of their contact details. Another topic in this taxonomy will be nagging. An example could be a service that repeatedly reminds people to complete their profile when they log in. The fourth one would be forced timing and action, such as, for example, a privacy notice that arbitrarily creates urgency or fear to share data with a third-party service. The fifth one will be privacy intrusive defaults, for example, a browser that collects payment information by default. And the last one regarding rewards and punishment. For example, punish people for not sharing their locator data by removing safety features. This taxonomy and research that we did and the conclusions that we came from was socialized with the data protection authorities, in particular in the European Union, but not only. And actually, we didn't receive questions or specific feedback until the guidelines were actually issued. I think this is sometimes a missed opportunity that we have in industry and all the stakeholders so important in order to discuss these research-based reports in order to make progress regarding how we can define this, because we have found more than 50 definitions of dark patterns in many different fields, so that it's not an easy task for anyone, I think, in the field. And I think there are many people who are definitely trying to do better in this area.
Yes, it's not easy at all. It's amazing how much knowledge you have in such a complex field, Cecilia, and all of you operating in this complex environment. On the subject of dark patterns, I'm mindful we're running over time here, but I'm happy to continue if you are for a bit longer. Perhaps, Cian, we could get your perspective on dark patterns, although it's not strictly covered by GDPR, I don't think. But what does this mean in terms of from the DPA's perspective?
Yeah, absolutely, Ben. You're correct that dark patterns aren't defined in the GDPR, despite the fact that Cecilia mentioned there are very many number of different definitions of dark patterns out there. The Digital Services Act does define dark patterns in the context of that legislation. It defines it generally around the design of interfaces in a way that deceives or manipulates individuals in respect of how they make decisions, either about their use of platforms or how they use the platforms. So even just applying that definition, which naturally doesn't apply under the GDPR, but applying that definition, we can see that dark patterns can result in infringements of the GDPR, despite the fact that dark patterns isn't defined in the GDPR. So, for example, it could result in transparency infringements if information is not provided in a clear and concise way. It could result in infringements of data protection by design, the principle of fairness, which we've discussed at length today. And also it could interfere with the lawfulness of processing, depending on the lawful basis that an entity relies upon. So I think Cecilia has given a very comprehensive account of the types of dark patterns, but just to touch upon that, perhaps some that might in particular touch upon personalization. I think the provision of selective information is a dark pattern that could interfere with the lawfulness and personalization of that we're discussing today. So if information is presented in a way that highlights the benefits of personalization but doesn't touch upon perhaps the risks or even how personalization is actually delivered, this is an issue that could infringe the transparency requirements of the GDPR. Similarly, if somebody's continually prompted to agree to a personalization option, that's something else that could interfere with the lawfulness of the processing or indeed the fairness of the processing. And similarly, if personalization is enabled, but in order to find the tool that disables that personalization, if that tool is hidden or difficult to find in an interface, that's something again that it's a dark pattern that could interfere with GDPR compliance, either based on lawful basis. If, for example, if withdrawing consent is more difficult than it is than providing consent, or again in respect of fairness as well. So I think in summary, I think that, it's quite clear that personalization can have a lot of benefits for data subjects. And it's certainly not the intention of the GDPR to inhibit those benefits to data subjects, but rather it really falls on controllers to ensure that they design their products and that they design their interfaces in a way that data subjects are aware of the personalization, that they have control over it, and that personalization doesn't unjustifiably have adverse consequences for data subjects.
Thanks, Cian. And that sort of takes us back nicely to where we started, really, with Cecilia's introduction, which is not about whether personalization is a good or a bad thing, or the pros and cons of it. It's clearly has all kinds of benefits. It's not whether you do it; it's how you do it. And it's great to hear the regulatory and the platform providers and the industry experts, and to hear you all sort of talking constructively about these issues to work towards solutions together. And it's certainly been an honour for me to convene this conversation and this conference. And thank you all for your support and your expertise. I'd love to hear more from you all. I have questions about. Well, I'd love to ask you, to be honest, about personalization. It's one of the benefits is that it shows you what you want, but also the beauty of the internet is that it's sort of infinite, and you could find out things that you don't want. So I'd love to have a chat another time about the sort of shifting that dial from personalization towards sort of throwing me up new things that other people are interested in, that maybe I'm sure Meta's already got that handled. But let's chat about that offline another time, Cecilia, if we may. And thanks, Michelle. Thank you, Giovanni. Thank you, Cecilia. Thank you, Cian. Thank you all so much for a fascinating conversation. And look forward to seeing you again soon in Brussels on the 26th of September for RAID Physical, when we all get together at the Stanhope Hotel. Very much looking forward to that. We're going to take a very short break now. I need to hop off and let the next panel get on board. They're going to be talking about bridging privacy, security, and borders, and they're coming from all over the world. Very much looking forward to that in about 10 minutes. Thanks.